With your lordship permission,
Yes.
may I make a mention with one unlisted item for motion, my lord? The reason is that today is the last date for filing our reply to the so-called notice, and there is an impending decision to terminate our engagement before the expiry of the engagement period. Our engagement will be terminated on 28 to 2026. Now, the government has given us a so-called notice only as a veil to comply with the natural justice principle. So there is a decision, impending decision to terminate whether we file a so-called reply or we do not file a so-called reply. There's a judgment of this.
Where are you employed as what?
We are employed as a part-time assistant professor, not as a regular. We do not claim for regularization. We only claim for that our extension may be till 28 to 2026, which was the original engagement. It was from 1/3/2023 to 28 to 2026. Now the government has taken a decision to terminate our engagement before this period.
Okay.
My lord.
Let's do tomorrow.
Today, my lord, because today is the last date for filing a so-called reply. If your lordship may be kind enough to list this matter of the part one, my lord.
Okay.
My lord.
Motion item 1.
May I please, your lordship? My lord, this petition is filed against the. This petition is filed against the respondent, wherein the respondents were illegally deducted 15% cess from the compensation amount that we have received in the month of January 2025. And the brief story of the case is that we are landowners, and our land was acquired under subsection 1 of section 3A of National Highways Act 1956. And by invoking Rule 47, Sub-Rule 4 of the Mizoram Land Revenue Rules 2013, the respondents were deducting 15% SSS.
15.
15%.
Isn't it? Not
Yeah.
50.
Yes, my lord, 15%. And we are highly aggrieved by their illegal action. And our prayer is that to refund the said 15% cess and along with its interest as immediately.
We will issue notice. I think some similar matters are pending before this court
My
on
lord,
appeal.
may I please take you to page number 69. In connection with the writ petition, this honorable court has already made judgment in respect of WPC number 35, 2022, and along with the WPC number 105 of 2021.
But I think there are some appeals pending regarding 15% deduction of the cess. There are some writ appeals pending, but I don't know whether the facts are the same or not. The act that is applied, the area. So we'll have to see. We'll issue notice, then the respondents will see whether there's any writ appeal pending regarding this. Have you found out whether there's a writ appeal pending against a judgment WPC 105/2021? See, there is a writ appeal pending regarding 15% deduction of cess. But I don't know the writ appeal number, the against which WPC. Anyways, we'll issue notice in the meantime. I heard Mr.
PC Lalthangmoy.
PC Lalthangmoy, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for the issuance of the appropriate writ or order to the respondents regarding the deduction of 15% of the compensation amount as cess by applying Rule 47 within brackets 4 of the Mizoram within brackets Land Revenue close bracket Rules 2013 in connection with the acquisition of his landed area, which was acquired for the maintenance and management and the operation of NH6 in the stretch of land from KM 121.45 to KM 138.55 within brackets Project Wang, Coliseum District HQ, close bracket, District Coliseum, full stop. The learned counsel for the petitioner submits that the landed property of the petitioners was acquired under the National Highways Act, 1956, and as such, the respondents deducting the 15% of the cess from the award. Where's the award?
Page number 60.
From the not award package 7 award list, is it?
Yes, my lord.
Within brackets Conpui to Mual Khan, close bracket. Yes, against the National Highways Act. He further submits that this is a covered matter by citing the decision of the coordinate bench of this court in WPC 35/2022 dated 05/04/2022 and WPC 105/2021 dated 11/11/2021. Stop. Notice be issued to the respondents. Ms. Zaram Sangui, learned CGC, accepts notice on behalf of
Respondent number 4.
respondent number 4, Mrs. Mary L. Kempe accepts notice on behalf of state respondents. Learned government advocate, okay, accepts notice on behalf of the state respondents number 1 and 2 and Mr. Samuel L. Changte, learned standing counsel for respondents number 5 and 6. Accepts notice on behalf of respondent number 5 and 6. Anyone else remaining?
Yes, respondent number 3, my lord.
Notice be issued to respondent number 3 through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks. Requisite copies of the writ petition to be duly furnished to the learned counsels for the respondents.
Duly obliged.
Admission item 2.
Lordship, I'd like to make one submission on behalf of the respondent number 5. He is intending to engage a senior counsel, so 2 weeks' time may be granted so that hearing can take place.
You are representing
Five.
respondent number 5.
Yes.
So previously it is Mr. Bilaram Enga, isn't it?
Yes, yes. In addition to him, the senior counsel will be engaged, it seems. All pleadings are completed now. So,
Okay, then we'll have to.
Can come
Mr.
up for
Joseph
hearing.
L. Rentley, learned counsel for the petitioner, is present along with Mr. Roshan Subedi, learned counsel for respondent number 5,
yes.
who submit. You are for respondent?
4.
Okay. Learned counsel for respondent and Mr. C. Lazoram Chana, learned counsel for respondent number 1 to 4. Full stop. The learned counsel for respondent number 5 submits that he has been informed that the respondent number 5 would like to engage a senior counsel in addition to his engagement, and therefore prayed for time.
My lord, if I may make one proposal, my lord. Since this is only with respect to the engagement of a senior counsel, my lord, it cannot take so much time, my lord. So let this matter come up on a fixed date on 28th of July, my lord, if that is possible.
My lord, my humble request would be sufficient time, but August 4th, by that time everything will be solved out, probably.
Okay, after 2 weeks.
Yes, and August 4th will become after 2 weeks.
My lord, so then fixed date on 4th, my lord,
4th of August.
4th of August.
Okay, has prayed for time. In view of the above, as prayed for by the parties, list on 4/8/2025.
Item 3.
This review petition, we have heard the matter to some length. What, let's dispose it off today.
Yes, Your Lordship. Since we're aiming for disposal, Your Lordship, just to recap, the facts of the case is very simple. There are two LSCs overlapping. We filed a complaint before the revenue court and it was decided in their favor and against me. So a settlement order was issued in that respect. So we have challenged that settlement order, number one. Number two is that we've sought for a declaration that my land should be declared as per my LSC. So that is the crux of the case. And the matter was rejected under Order 7 Rule 11 of the CPC at the preliminary stage. So basically that is the facts of the case. Now in the last court order, Your Lordship, I had sought Your Lordship's permission
Time,
regarding going through the provisions of the Assam Land and Revenue Regulations.
okay,
In light of this judgment and order dated, bearing citation number 2002-3 GLR 473, Thanda Bala Chaudhary case. Now, in this case, Your Lordship, they have specifically spoken about two provisions of this regulation. That is regulation number 62 and regulation number 154, which is similar to our section 96. It's not the same, but similar. In any event, Your Lordship, with Your Lordship's permission, I would like to read the judgment and order that I've just cited, para 3 onwards. Now, the petitioners, as the plaintiffs, have instituted the title suit number so and so before the Learned Civil Judge Senior Division 2, Guwahati, against the defendant respondent for declaration of right, title, and interest over the suit land with a prayer inter alia for recovery of the possession. The respondent has contented the suit by filing written statement. Initially, the petitioners moved the revenue court for perfect partition of the suit land, claiming their respective shares thereon. Having failed to get their grievance well redressed, the instant civil suit has been preferred by the petitioners. The learned civil judge, upon hearing the learned counsel for the parties, has framed the following 8 issues. Now, out here, Your Lordship, at the outset, what I would like to point out is that in this case, initially, the petitioners had moved the revenue court. So thereafter, they moved the civil court. I'll just skip the issues, Your Lordship. Coming to para 4. The only question that needs to be answered here is whether the learned civil judge has committed any illegality or irregularity in holding that In view of provision under Section 154 of the Assam Land Revenue Regulation, for short the regulation, the issue of cause of action and maintainability of the suit, as mentioned in issues number 1 and 5 above, can be decided as preliminary issue where only material proposition of law is involved. I've heard Mr. B.P. Kataki, learned senior counsel for the petition. I also heard Mr. So-and-so. Challenging the impugned orders, Mr. Kataki, the learned senior counsel, has contended that both the impugned orders ex facie suffers from gross illegality and jurisdictional error. He has put forward his arguments to dislodge these impugned orders mainly on two grounds. Firstly, it is argued that the learned civil judge has committed a grave error of law in observing that since two perfect partition cases between the parties in respect of the suit land have already been disposed of by the learned deputy commissioner, and as per the defendant's respondents, both the plaintiffs and defendants are possessing their land separately as per partition in view of Section 154 of the regulation, the jurisdiction of the civil courts from taking cognizance of the allegation made in the present suit by the plaintiff's petitioner is barred and as such not maintainable, having no cause of action, and accordingly issues of cause of action and maintainability of the suit have been taken to be decided as preliminary issue. Mr. Kataki has contended that the application of provision of Section 154 of the regulation has, on the face of the material available on record, no applicability in the present case, inasmuch as the instant suit has not been filed for any perfect partition, but only for declaration of right, title, and interest over the suit land. Though earlier, the petitioners approached the revenue court, having failed to get any relief therein, the instant title suit has been instituted against the respondents. According to him, once a suit is filed for declaration of right, title, and interest, the bar imposed under Section 154 of the regulation does not come into play. A catena of judicial decisions have been referred by Mr. So-and-so to drive home his submission. In Dandiram Nath and another versus Mihiram Nath Chamua, decided on so-and-so, reported in one so-and-so, this court, speaking through Justice Sarju Prasad, Chief Justice, categorically ruled that Section 154 cannot deprive a man of his title to the land. The mere fact that the lands have been distributed or revenue collected, allotted, will not confer any title on them, and it would be always to the civil court to adjudicate upon the question of title, irrespective of the provisions of Section 154. Dealing with a case where the plaintiffs instituted a suit for declaration of title and confirmation of possession, or in the alternative, recovery of possession, the court in paragraph 3 of the said ruling observed as follows. On behalf of the appellants, however, it had been argued that Section 154(1)(f) of the Assam Land and Revenue Regulation is a bar to the institution of the suit. Section 154 says that except where otherwise expressly provided in this regulation or in rules framed thereunder, no civil courts shall exercise jurisdiction in any of the matters enumerated in the various clauses of the section, one of them being Clause F, which relates to distribution of land or the allotment of revenue on partition. The distribution of land or the allotment of the revenue may very well stand, but I do not see how Section 154 can deprive a man of his title to the land. If the defendants had no title thereto, then the mere fact that the lands have been distributed or revenue allotted will not confer any title on them, and it will always be open to the civil court to adjudicate upon the question of title irrespective of the provisions of Section 154. A reference in this connection may be made to the decision of the Calcutta High Court in so-and-so, where it was pointed out that a partition, whether perfect or imperfect, of revenue-paying properties must be made by the revenue authorities. This follows from a perusal of the Section 96 with Section 154(1)(e) of the Assam Land and Revenue Regulation. Now, I would like to emphasize on the following sentence. But the jurisdiction of the civil court to determine the rights of the parties to the property in dispute, as well as shares to which they are entitled to, has not been taken away by the regulation in question, and it is for the civil court to decide whether the property is or is not liable to partition. The same views applies to the other clauses of Section 154. In the circumstances, I find no substance to the point urged by the learned counsel of the appellant. In my opinion, the appeal is without any merit and must be dismissed with cause, and the decision of the Court of Appeal below should be maintained. In the case of State of Assam versus Silfat Ali, reported in so-and-so, a division bench of this court also held that Section 154(1)(a) of the regulation does not debar the civil court from entertaining the suit based on title to property. In another case reported in so-and-so, it was held by this court that Section 154 does not preclude the civil court to entertain a suit based on title to the property. it was observed that matters within the jurisdiction of the revenue authority or courts could be decided by them, but no such decisions can take away the jurisdiction of the civil court when a person having a right to an asset claimed entitlement to it and sought a declaration of his right in the civil court, notwithstanding the provisions contained in section 1541 of the regulation. A special bench of this court in Dolat Ram Lakhani versus State of Assam and others reported in so, speaking through Honorable Hansaria J, in paragraph 22 of the judgment held that civil court's jurisdiction would not be barred where the plaintiff seeks declaration of his right over the land from which he is sought to be evicted. Again, in Sukumari Dev and others on the death of Mahindra so, his legal heirs, Madan Dev and others reported in so, our High Court had the occasion to deal with both section 62 and 154 of the regulation, wherein the question of jurisdiction of the civil court came up in deciding a dispute regarding title of a property and cancellation of mutation in the revenue record. On careful perusal of both 62 and 154, it was clearly observed that the civil court is the best authority to decide the title of the property. In a recent decision in Urmila Bala Das versus Bhubaneswar Das and others reported in so, this court observed that a suit for declaration of title in injunction is never barred by section 154 of the Some Land and Revenue Regulation. And the remaining speaks about order 14.2 of the CPC, so I will stop there, Your Lordship. Now, in the instant case, Your Lordship, during the course of the appeal, clarification was sought by this honorable court. With Your Lordship's permission, I would like to take Your Lordship's attention to page 96 of my review petition. Now, out here, the subject itself clarifies that clarification of the query made under order dated 10/8/2023 in RFA number 29 of 2023. If Your Lordship can kindly turn to the second paragraph.
Yes.
As per section 106 of the Mizoram Land Revenue Act 2013, the civil court is only barred to set aside or modify any order made in respect of land revenue, assessment, collection of land revenue or taxes, or imposition of penalty on area. As such, there is no bar for civil court to make decision in dispute regarding boundary possession and ownership of property. So a clear clarification was issued that it does not bar the court jurisdiction of the civil court in relation to declaration of title.
Okay.
So secondly, Your Lordship, it was contended by my learned friend that since I have already approached this revenue court, I should continue there, and the two processes cannot go together. Now that, unfortunately, in my humble opinion, is a slight misinterpretation of the facts. Now, in our plaint, I can show Your Lordship, if Your Lordship wishes, how this issue came up was, I filed a complaint before the concerned authorities, the revenue authorities. Thereafter, a settlement order was issued. I have not challenged that settlement order in the revenue court. If Your Lordship can kindly, I would like to take Your Lordship's attention to section 76 of the Mizoram Land Revenue Act.
Yes. We'll have to look at the plaint,
I can show you, Your Lordship.
copy of the plaint.
Absolutely.
Anyway, we'll look at the revenue.
Yes, we'll look at the revenue provision and then I'll take Your Lordship's to the plaint.
Yes.
Section 76. This is the situation under which a revenue officer will be considered to be a revenue court. 76(1), Your Lordship. May I read?
Yes.
A revenue officer, while exercising power under this act or any other law for the time being in force, will inquire into or to decide on any question of fact or law arising out of orders, not arising out of complaint. It's arising out of orders for determination between the government and any person or between the parties to any proceedings shall be a revenue court. So if I had challenged that settlement order before the revenue authorities, whoever that revenue authority will be considered to be a revenue court. But that is not the situation
So
here.
you're saying in the instant case, it is not a revenue court?
No, it's not, my lord.
Okay.
My plaint, your lordship, coming to my plaint.
Copy of the plaint is here?
I've annexed it at page 27, annexure 2. If I can take it, sorry. The relevant page is at page 3030, para 3. May I read, your lordship? That in the first week of the month of January 2021, the family of the plaintiff came to know that on so-and-so date, the defendant number 1 and 1 surveyor, namely Mr. So-and-so, went to the land of the plaintiff by displaying the LSC number so-and-so and LSC number so-and-so and erecting boundary pillars within their land without taking prior permission from the competent authority and without the knowledge and consent. That on 7/1/2021, the plaintiff submitted a written complaint to the defendant number 4 requesting to take action against the defendant number 1 and to solve their problems. This is how it started. So the complaint copy is at page 50, and translated version is at page 51.
Okay.
So my humble submission on this issue is that since we have challenged,
It is not against an order, but a complaint. That's
correct,
the main-
correct, that's how everything started. So whoever, we have not approached the revenue court as per the provisions of section 76(1). That is the emphasis that I'm trying to make, Your Lordship. And regarding the jurisdiction, the review jurisdiction of this honorable court, I would like to place one judgment only. This is 2019-20 SEC 753. Para
2019?
volume 20, SCC 753. Out here, this the apex court had laid down the conditions under which a review petition may be entertained. The relevant paragraph is at page 15.1.
Para?
15.1.
Para 50.1?
15.1.
15, okay.
15.1.
Yes.
Your Lordship has it? May I read?
Yes, please go ahead.
In Indrachand Jain, it was observed in para 10, 11, and 33 as under. It is beyond any doubt or dispute that the review court does not sit in appeal over its own order. A rehearing of the matter is impermissible in law. It constitutes an exception to the general rule that once a judgment is signed or pronounced, it should not be altered. It is also tried that exercise of inherent jurisdiction is not invoked for reviewing any order. I'll just keep para that 33, the internal para. The High Court had rightly noticed the review jurisdiction of the court, which is as under. The law on the subject is exercise of power of review, as propounded by the apex court and various other high courts, may be summarized as hereunder. Review proceedings are not by way of appeal and have to be strictly confined to the scope and ambit of Order 47, Rule 1 CPC. Power of review may be exercised when some mistake or error apparent on the face of record is found, but error on the face of record must be such an error which must strike one on mere looking at the record and would not require any long-run process of reasoning on points where there may conceivably be two opinions. Power of review may not be exercised on the ground that the decision was erroneous on merits. Now, I would like to rely on this emphasis on the next 2 points. Power of review can also be exercised for any sufficient reason, which is wide enough to include a misconception of fact or law by a court or even an advocate. So,
Okay.
in the present case, Your Lordship, in all probability, I may have made some mistake in my submission, but the fact of the matter is that the revenue authorities had clarified that they did not have the jurisdiction to entertain issue of title in their clarification, which was as a result of clarification sought by this honorable court. Most probably, I did not emphasize on that during the hearing, or as well as I should have. But in any event, Your Lordship, since that is the case, in my humble opinion, your lordship has all the power to review the present case and decide on the facts of the case. And so in light of that, your lordship, my humble prayer is that your lordship may be pleased to exercise his power of review. And lastly, I apologize. Just one last point. In the last court date, my learned friend had raised that issue that since in light of the clarification, the second clarification issued by the Revenue Department,
Later date, huh? Yes.
wherein they have stated that Section 93 referred to in Section 97 of the Revenue Act is a typographical mistake and it should be read as Section 96. Now, the contention of my learned friend was that it requires an amendment. It should be done by only the Assembly. In that regard, your lordship, I would like to take your lordship's attention back to the Revenue Act. Now, this is not a case where we are saying that any provision is illegal or wrong, but there is just a difficulty in interpreting due to the typographical mistake. In that regard, I would
Because
like,
it didn't make any sense actually.
yes, your lordship.
You know, when it says,
Even they themselves have admitted to that. So regarding that, I would like to take your lordship's attention to Section 128 of the Revenue Act.
Yes.
This is power to remove difficulties.
Yes.
May I read, your lordship? Section 128, power to remove difficulties. If any difficulty arises in giving effect to the provisions of this Act, the state government may, as occasion may require, by notification in the official gazette, take any action not inconsistent with the provision of this Act which appears necessary or expedient for the purpose of removing the difficulty. So in light of this clarification, the state government can easily issue a notification saying that this is a typographical error. So there's no requirement of an amendment by the Assembly or anything like that. And lastly, what I would like to mention is that as the record shows, the civil suit before the trial judge was at a preliminary stage. Even if this review is allowed, your lordship, which I'm hoping, no prejudice would be caused to the respondent. They can still adjudicate their claim before the trial court. There will be no prejudice to anyone at all, because the entire issue is yet to be determined. With that, your lordship, I would like to conclude my submission.
Yes.
Maybe please, your lordship. First of all, your lordship, I'd like to submit the point regarding the review, lordship. We must not forget about the present case, which is a review case, your lordship. And in the previous case also, in the previous hearings also, lordship, I submitted that this case is a review matter, not an appeal, lordship. For that, your lordship, I'd like to draw your lordship's kind of attention in referring one judgment rendered by the Apex Court in Kamlesh Verma. That is 2013, lordship, volume 8, SCC 320. 320, lordship. Page number 320. Relevant para is page number, starting from page number 19, lordship. Page number 19.
Para?
19 onwards.
19.
19 onwards, lordship.
Yes.
May I read the lordship?
Yes.
Review proceedings are not by way of an appeal and have to be strictly confined to the scope and ambit of Order 47, Rule 1 CPC. In review jurisdiction, mere disagreement with the view of the judgment cannot be the ground for invoking the same. I'm going to repeat, lordship. Mere disagreement with the view of the judgment cannot be the ground for invoking the same. I'd like to pause here, lordship, for a moment. Basing on a perusal of the whole submissions of my learned friend, even from today, lordship, and also from considering the submission, the review petition, lordship, it is 100% clear that It's a simple disagreement of the view taken by this honorable court in the previous RFA lawsuit. No more that lawsuit. So, basing on this judgment in lawsuit, it is very clear and certain that mere disagreement with the view of the judgment cannot be the ground for invoking the review and invoking the same. I continue the lawsuit, the next sentence. As long as the point is already dealt with and answered, the parties are not entitled to challenge the impinged judgment in the guise that an alternative view is possible under the review jurisdiction. As if for that, the lawsuit, this honorable court already held that, yes, once a decision is rendered by the revenue officers as a revenue court, it cannot be reopened before the civil court. That's already decided, the lawsuit. And even on consideration of the submissions made by Parliament friend today, lawsuit, there's nothing new. The only thing is to make another word interpretation in lawsuit. So that's not the scope of review lawsuit. This is not an appeal lawsuit. And para 20 lawsuit. Para 20. Thus, in view of the above, the following grounds of review are maintainable as stipulated by the statute. When the review will be maintainable, number one, discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the knowledge of the petitioner or could not be produced by him. There's no point in this number one lawsuit. Number two, mistake or error apparent on the face of the report. There's no point at all in the petition mentioning the error rendered by this honorable court. And number three, lawsuit, any other sufficient reason. So that must be taken in consideration, lawsuit. The words, the continuing sentences, lawsuit, the words, any other sufficient reason, have been interpreted in Chaju Ram versus Neki and approved by this court in Moran versus so to mean a reason sufficient on grounds at least analogous to those specified in the rule. The same principle have been reiterated in so and so. So meaning that, the third point, the third subject of the review, any other sufficient reason is to be read as analogous with the previous one, So there's nothing new in this petition. So, para 20, point number 2, when the review will not be maintainable. Number 1, a repetition of all an overruled argument is not enough to reopen concluded adjudications. So, the submissions rendered by Malan friend is already overruled by this honorable court in the review in the appeal. Number 2, minor mistakes of inconsequential important. Number 3, review proceedings cannot be equated with the original hearing of the case, Basing on the whole submissions, we are reopening up the case, So that's not allowed under the review, under the very limited scope of the review. And the next page, Roman number 5. Can you take you at Roman number 5? A review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected, but lies only for patent error, It's very clear. Number 6, the mere possibility of two views on the subject cannot be ground for review. And number 7, the error apparent on the face of the record should not be an error which is to be fished out and searched. Fished out and searched, Number 8, the appreciation of evidence on record is fully within the domain of the appellate court. It cannot be permitted to be advanced in a review petition. Number 9, review is not maintainable when the same relief sought at the time of arguing the main matter had been negative. It's very clear. Para 21, the last para lawsuit. Keeping the above principle in mind, let us consider the claim of the petitioner and find out whether a case has been made out for interference exercising the review jurisdiction. So, keeping in mind the spirit of this decision, I must conclude in my point number 1, that at all there's review, the very limited scope of review cannot permit my learned friend to argue in such a manner, So that is my first submission, And the next thing is, My point number 2 is that, Your Lordship, at present, Your Lordship, as Your Ladyship is much aware of that, there is a rapid increasing number of pending cases before court across the country, Your Lordship. To tackle this problem, it is the policy of the judiciary these days that settlement outside court, maybe by way of conciliation, mediation, arbitration, it's strongly advocated these days, Your Lordship. So, the legislative intention is also one of such, Your Lordship. So, for that, Your Lordship, the review officers are empowered to make their own decisions in revenue matters like boundary disputes, Your Lordship. So, I must say that, Your Lordship, in boundary dispute, the review officers, the staff are expert. They are expertise in that field. And I would like to add that, Your Lordship, even if the court is to make decision in this subject matter on merit, at least it must seek the assistance of the review officials to make spot verification, to demarcate the land, to measure out the petitioner's land, to measure out the defendant's land. So they are expertise in their field, Your Lordship. So I must say that at least 99% of the boundary disputes, revenue disputes, are settled with the assistance of the revenue officials. So this act also empowers the very limited boundary disputes and its connected matters on Your Lordship, not the issue of title. They are not entitled. They are not empowered with regard to the title, the ownership, the inheritance of the land, Your Lordship. It's only regarding boundary dispute. So for that, Your Lordship, I would like to say that in this present case also, we must remember that, like what my learned friend already read out in one portion of the plaint, it is very clear that it is totally a boundary dispute. Lordship, for that, Your Lordship, I may like Lordship to take you at page number, the plaint, page number 30, even though my learned friend already read out the Lordship, page number 30 of the petition.
Yes.
This is the genesis of this case, Your Lordship. Page number 30, para 3, I'm reading, Lordship. That in the first week of the month of January 2021, the family of the plaintiff came to know that on 30/12/2020, the defendant number 1 and 1 surveyor, namely Pulalunema, went to the land of the plaintiff by displaying the LSC number so-and-so and LSC number so-and-so and erecting boundary pillars within their land without taking prior permission from the competent authority and without their knowledge and consent. That on 7/1/2021, the plaintiff submitted written complaint to the defendant number 4, requesting to take action against the defendant number 1 and to solve their problems. It's not a matter of title. It's a matter of dispute, boundary dispute. I'm just keeping that, Your Lordship. And again, Your Lordship, page number 40. Page number 40.
Yes.
I'm sorry, page number 39, Lordship. Starting from page number 39. Para 12. The cause of action. May I read, Lordship. The cause of action arose since 30/12/2020 when the defendants number 1, brother Lalun Lua and 1 surveyor Lalun Nema, took action by erecting boundary pillars and displaying the 2 LSCs of the defendant number 1 within the land of the plaintiff without prior office order, permission, and without the knowledge and consent of the plaintiff and her family members, and it continues till date. And continuing, Your Lordship, page number 40, the prayer portion in the original pleading is that number 1, Lordship, para 15, Roman number 1, to pass an order in favor of the plaintiff, declaring that the settlement order 17/1/22 passed by the defendant number 3 without conducting spot verification is null and void and is baseless. Your Lordship, I'm posing here regarding the spot verifications. I have many things to say, but I'm not going there, Your Lordship. The only thing which I'd like to point out in this point is that this particular settlement order is arising out of boundary dispute. It's only boundary dispute, which is totally the domain of the revenue officials, Your Lordship. For that, Your Lordship, we should not be confused and mixed up with the judgment which my learned friend already read out, that is Thanda Bala case, Your Lordship. My point number 3 is, Your Lordship, now coming to the judgment delivered by Gauti High Court in Thanda Bala case, Your Lordship. That is purely the question of title, Your Lordship. That's a title. My learned friend already read out the judgment, but I'd like to repeat some portion of the judgment, Your Lordship.
Yes.
Para 19 of the judgment. Para 19. I'm reading, Lordship. Keeping in view the above cited authorities relating to the jurisdiction of civil court under section 154 of the regulation, and also on ordinary reading of the provisions of section 154, as well as section 62, which is also a saving clause as noted above, it can be safely said that the legal position is well settled that civil court has the jurisdiction to agitate upon the matter relating to title over the property. Title over the property. It is correct that if any claim is made as regards perfect partition, no civil court shall exercise its jurisdiction as envisaged under section 154. I'm pausing here, Lordship. Section 154 talks about the bar of jurisdiction of civil court, including perfect petition. Perfect petition, in my humble opinion, is that, Your Lordship, in this case also, in my understanding, one person passed away, and after his death, there was application filed before the revenue authority, let's say the revenue court, for petition of their landed properties. The revenue authorities, after doing their formalities, made petition of that particular land. But one person is not happy with that petition, stating that I have the title over the property. So that is the origin of the case in my understanding, Your Lordship. So in this judgment also, it is very clear that yes, even though perfect petition is the total domain of the revenue officials, but the title, the question of the title is still open to the civil court, Your Lordship. That is the decision of this honorable court, in my understanding, Your Lordship. So this judgment, in fact, is not squarely applicable in this present case, so long as this judgment, as from the plain reading of the very pleadings, shows it's a boundary dispute. There's no dispute as to the title of their LSC, and they are also not denying our LSC. But the only thing is there are some overlapping areas. That's the only issue in this case, Your Lordship. So, Your Lordship, to conclude, I'd like to submit before this honorable court that so long as the very limited scope of review cannot spare my learned friend in arguing that matter, so the mere possibility of two views, the mere possibility of two interpretations cannot be a ground for the review. And even on merit, Your Lordship, this is such a situation where the revenue officials could simply do the re-verification. They state that the matter was done, the settlement order was made without proper verification. They can approach the higher forum, maybe the secretary, or maybe by way of revision, praying another redemarcation or verification. So, Your Lordship, that's a very simple matter. Thereafter, the matter may be decided. And for real last, Lordship, I'd like to say that.
Final last.
Yes. Final last. Like I have already stated before, Your Lordship, in the previous argument, we must not confuse that if I have a boundary dispute, I have two choices. One is to approach the revenue court, another is to approach the civil court. If I approach the civil court, that procedure must be governed by the Mizoram Civil Courts Act 2005 in consonance with CPC. There is a provision of appeal, review, revision. If I'm not happy with the civil court's decision, I cannot just challenge the same to the revenue code, Your Lordship. Like that, if one is approaching the revenue code, that must be governed by the Revenue Act 2013 and the rules made thereunder. And that rules, that act itself provides the provisions of an appeal, the provisions of a review, the provisions of revision. So, Your Lordship, that two acts, the two codes are going similar, going parallel, I mean. So, in that particular point, Your Lordship, if today's decision is made in favor of the petitioner, that should have, Your Lordship, consequential effect, Your Lordship. So, it should be an interference of the revenue act itself, as well as the revenue officials in dealing with their power in settlement of the dispute, which may be have future effect even regarding the pendency of the cases, as well, Your Lordship. So to conclude, Your Lordship, my humble submissions is to dismiss this review petition.
Okay, now look at section 76. It says that, section 76,
Lordship.
it says that all law arising out of orders. One point he had raised is that revenue court's jurisdiction.
Lordship. Yes.
Any question of law or of fact arising out of orders. So his contention was that the order made by the impugned order, whichever, is not an order made by the revenue court.
Lordship.
That one is his point, because under section 76, revenue court will decide matters which is an order.
Lordship.
If you're unhappy with some order, he says this is an order, this is an application made. So the impugned order is not an order made by the revenue court.
Lordship.
You have not addressed that point, huh?
In my understanding, Your Lordship, first and foremost, Your Lordship, that particular interpretation is not the scope of review. That is the first point. And the second point, Your Lordship, even admitted, I'm reading again the subsection 1.
76, huh?
A reviewing officer, while exercising power under this act or any other law for the time being enforced, will inquire into or decide on any question of fact or law arising out of orders for determination between the government and any other person or between parties to any proceedings shall be a revenue court. My understanding is that, Your Lordship, the very first line, a revenue officer while exercising power under this act. So, in reading the whole text of 2013, the revenue officers are empowered to do certain acts, certain activities, certain functions, including, Your Lordship, in this particular act also, section 81, section 82, section 80, there are many other functions which will be undertaken by the revenue officers, like entertaining some complaint, maybe some evidence, maybe transfer of cases, maybe enforcement of attendance of witness, hearing of the case, use of force. Section 86 provides use of force, etc. I'm not talking them all, Your Lordship. So my understanding is that while exercising power under this act, 2013 Act, from section 1 to the last section, they are functioning as a revenue court. That is my understanding, Your Lordship, my interpretation, Your Lordship. So anyway, Your Lordship, the first and foremost is that interpretation is not the scope of the review, Your Lordship. It's not an appeal. That is my understanding, Your Lordship.
Okay. Yes. Anything else?
Just a small rebuttal, Your Lordship. Number one is that my learned friend has read out the prayer portion of my plaint. But I believe that the entire plaint has to be appreciated in its entirety. Page 40 of my review petition. My learned friend had read out 15.1. Para 15.1. But if we kindly turn to the next page at my prayer number 3, to pass a decree in favor of the plaintiff, declaring that the plaintiff is the rightful owner. It is not a case where I was just only challenging the show cause or a settlement order. I've prayed for declaration as well. Number two is that my learned friend has stated that the Thanda Bala case will not be applicable in the present case. In my humble opinion, Your Lordship, again, that is a wrong interpretation due to the fact that this is not a case of partition. My understanding of partition is that if one LSC is partitioned into two for in respect of, let's say, Mr. A and B, and we are not happy with the manner in which the partition takes place, then definitely I have to go to the revenue court. But this is a case of two LSCs overlapping. This is not a case of one LSC being partitioned and then a dispute arose. No, I have been issued a valid pass. They have been issued a valid pass by the same authorities. There is overlapping. So this is not a case of partition as such. The Thanda Bala case is squarely applicable in the present case. Now, my learned friend has stated I should go for appeal so and so, but since my learned friend has already read out 76, I will not press on that because there is no question of filing an appeal before the revenue authorities because I've never approached the revenue court in the first place. Now, also my learned friend has stated that there is no scope of review regarding interpretation of section 76. But the 2019 judgment, which I've read out earlier, now out there, Your Lordship, they have in a way defined the meaning of sufficient reasons as mentioned in Order 47. Now, it clearly says that for any sufficient reason, which is wide enough to include a misconception of fact or law.
Okay.
So, in my humble opinion, that is within the scope of review. With that, I conclude my submission.
Yes, heard Mr. Dalfakoma, learned counsel for the petitioner.
Apology, Lordship. May I make
What?
only
What?
one citation, Lordship?
One more citation. Okay.
Lordship.
Oh, you
My
forgot.
deep apology. That is, Lordship, 2022.
Yes, 2022.
Volume 17, SCC, page 657. I'm so sorry, Your Lordship. Para number 11 and 12.
What does it say?
I'm reading,
It
it's
is-
very simple, Your Lordship. I'm reading. Para 11 and 12.
Yes.
The Urban Land Sealing and Regulation Act 1976 is a self-contained code. Various provisions of the Act make it clear that if any orders are passed by the competent authority, there is provision for appeal, revision before the designated appellate and revisional authorities. In view of such remedies available for a aggrieved party, the jurisdiction of the civil courts to try suit relating to land, which is subject matter of sealing proceedings, stands excluded by implication. The civil court cannot declare order passed by the authorities under ULC Act as illegal and non-est. More so when such orders have become final, no declaration could have been granted by the civil court. And para 12, Your Lordship. In this case, it is clear from the orders passed by the competent authorities that the original declarant was holding excess land to the extent so and so. When the orders passed by the competent authority and consequential notification issued under section so and so have become final, it was not open for the respondent to file a suit seeking declaration as paid for, as we are of the view that jurisdiction of the civil courts is barred by necessary implication. Trial court failed in error in entertaining the suit as filed by the respondent, and even the first appellate court and second appellate court have not considered the various grounds raised by the appellant in proper perspective. That's all, Lordship.
Okay. Yes, heard Mr. Alal Omar, learned counsel for the petitioner. Also heard Mr. T. Dalmansiama, learned counsel for the private respondent. Hearing concluded. Matter reserved for order.
Deeply obliged.
Item 4.
Your Lordship, in this case, I would like to again pray for some time. We were directed to effect service by way of newspaper publication in Guwahati.
To respondent number?
3. So, we have already
What
sent
about the
the
other respondents?
steps have been taken.
AD card from respondent 4 and 5 is still awaited. Then
2 is
Dusty mode have you served to respondent number 1?
one is completed, Your Lordship.
Okay, notice has been served. Okay, complete. Then, so we are allowed you to take steps for issuance of notice upon respondent number 3 through newspaper publication, and 4 and 5 through registered post.
My lord.
So 3, have you done, taken steps for newspaper publication?
I have taken steps, but the
Not
newspaper is yet to
Okay,
publish it.
Okay, okay. Then 3 and 4? You have to wait for return. 3 and 5,
4 and 5.
or 4 and 5. We have
Yes,
to
we
wait
have to-
for return. Is it? Take step for fresh 4 and 5 through registered post, not returned yet. Okay. Heard Mr. Lal for comment, learned counsel for the appellant who has paid for time for filing the affidavit showing the service of notice to respondent number 3 through newspaper publication. It is also seen that AD card for respondents number 1 and 4 and 5 is not returned till date. In view of the above, list after 3 weeks.
Obliged.
Item 5.
My lord, I will receive vetted affidavit in opposition. However, that was printed out in legal size. That is why we have to prepare first.
Okay.
I
Anyway,
need to
who's
give
for the
them some more
petitioner?
time.
No one has appeared? Okay, yes. So now she has received the affidavit, but it was given in an what, legal size? So a short period.
Yes, my lord.
Yes, my lord.
We'll give her 2 weeks time. Mr.
My lord, there is interim order.
Yes, okay. Mr. B. Chakma, learned counsel for the petitioner is present through BC, while Ms. Zaram Sampui, learned CGC for respondent number 2 and 3, has paid for a short date for filing the counter affidavit. In view of the above submission, list the matter after 2 weeks.
My lord, interim order to be considered. also.
Meanwhile, the interim order passed earlier shall continue till the next date of listing.
Humble request. Humble
Item
request.
6.
Yes, what does it say?
Worship, may I seek another 2 weeks, 3 weeks time for filing affidavit in opposition? The matter is listed for the second time.
Yes,
Similar prayer for respondent number 1.
Mr. B. Rukung Abautu, learned counsel for the petitioner is present, while the learned counsels for the respondents have all prayed for time to file their counter affidavit. Full stop. It is also seen that AD card from respondent number, return of AD card, okay, from respondent number 5 is still awaited. In view of the above, list after 3 weeks.
Orders items 7 to 9.
Yes,
Mr. Lordship, as per the last court order, I am to take instructions from my client regarding whether the matter has to be listed for amicable settlement before the
oh
law
yes.
appellate. Yes, my Lordship, in this regard, I have spoken to my branch manager, the branch manager, and he is of the opinion that the policy, the insurance policy covers only liability only policy. So
You don't want to refer the matter?
yeah, but since in our opinion, since the matter has to be decided between the claimant and the owner of the accident vehicle, so if those two parties were willing to send the matter, we have no objection to the same.
Lordship, the owner of the accident vehicle is not contested, so I don't think there will be a possibility for your settlement.
Okay, so no, the same for settlement.
Lordship, yes.
Then in mediation, as per the rules, if their parties come to a settlement, they have to pay a certain amount of fee to the mediators also. There's a certain, I think, 5,000 or 2,500. Anyway, what is the stage in this case? Besides, before it was referred to
Your Lordship, we have
respondent number 3.
yes, we have just submitted the service report.
No one is representing respondent number 3. Respondent number 3 is the owner, is it?
It's a driver, if I'm not mistaken, driver of the accident vehicle.
Driver.
Yes.
Then who is the owner?
Owner is the
Respondent number
respondent number 1.
1. Who is representing respondent number 1?
Respondent number 1 is not represented, Lordship.
Yes.
Now, this is MAC appeal number 1. Now here, this court's order dated 19/06/2025 shows that Mr. Lalwat Fela, Learned Counsel for that service is complete upon all the respondents in MAC appeal number 1. How is it complete?
Yes, all have been completed. We are allowed to make personal substitute service by way of Dusty.
Let's see.
So you have served the respondent number 3 personally, and
Okay, who
affidavit
is
in-
there's a counsel, Mr. M. Pachwa, Michael, is it?
He's
M.
my
Pachwa?
junior, Lordship. He's my
Okay.
junior.
Appearing for respondent number 1.
One,
So
Lordship.
you are for number 1, submits
number
that he has instructions to appear for respondent number 2 as well.
Lordship,
So you're
yes.
representing 1 and 2.
Yes, Your Lordship, in MAC appeal number 1, I'm representing respondent number 1 and 2.
Okay, so it's complete.
Lordship,
So
yes.
3, Dusty,
Dusty.
That's the Lordship, yes.
reserved, no one is representing, isn't it? Huh? Anyways, so Mr. K. London Liana, Learned Counsel for the petition, appellant is present, along with Mr. Johnny El Toto, Learned Counsel for respondents number 1 and 2. The learned counsels submit that the parties are not willing to have their matter referred to, have their matter referred for mediation. In view of the above, it is seen that service of notice upon respondent number 3 is complete through Dusty mode, wherein
Even respondent number 4 also. Lordship. Respondent number 4 is the driver of the vehicle.
no, in MAC appeal 1, okay, is complete upon respondent number 3 and 4 through Dusty mode, wherein the affidavit reflects that notice was received by respondent number 3 or the single Mona is respondent number
Yes, respondent number 3 also.
or by respondent number 3 on 12/6/2025, and where's 4?
4 is someone is annexer 2, Lordship. Annexer 2 of the affidavit. He received the Summons on 10/6/2025.
Okay, and notice was received by respondent number 4 on 10/6/2025. However, none appeared for respondent number 3 and 4. We may wait for respondents number 3 and 4 to be duly represented. List after 2 weeks. Give them a chance. Yes. Now in the next back appeal number 2, Dusty mode to respondent number Weldon Thara is respondent number
Number 2.
2. One is represented.
Yes, Your Lordship. One is the claimant. I'm
Okay.
representing
Yes,
respondent number
Mrs. K.L. Digdana, learned counsel for the appellant is present along with Mr. Johnny L. Tocho, learned counsel for respondent number 1. It is submitted that the parties are not willing to have their matter referred to for for mediation. Good stop. In view of the above, it is seen that notice upon respondent number 2 is complete in the affidavit, wherein it is seen that notice was received by respondent number 2 through Dusty mode on 12/6/2025. However, none appeared for respondent number 2. We may wait for respondent number 2 to be duly represented, list after 2 weeks. Now in MAC appeal number 3,
Lordship, in the MAC appeal number 2, there is as many as 3 respondents, and the third respondent, I don't know whether steps has been taken by my lord.
2, in MAC appeal number 2.
Yes, Your Lordship.
So
One
Dusty
is-
was only to respondent number 2. What about 3?
Yes, 3.
Even the three also have received it. I think service report will be there in the case record. Unfortunately, I don't bring my case
Wait,
record.
we'll have a look. 2 through Dusty mode. The same person or what? Yes, notice is deemed to be complete upon respondent number 3. Now in MAC appeal number 3, you're representing, Mr. Johnny is representing
Respondent number 1 and 2.
1 and 2, so 3. Then I think it's same order as the first one. Okay. After 2 weeks.
Thank you, Lordship.
Item 10.
Yes. Who is appearing? Yes, for the state.
Mr. Lordship is a bail application lordship. The applicant herein was arrested way back on 25th of September last year, lordship, 2024, for alleged possession of certain commercial quantities of white powder suspected to be heroin, lordship. And thereafter, till date, my lord, he is now in custody. And charge sheet also has already been filed by now, and trial is going on, lordship. So my ground of bail before your lordship is non-compliance of the statutory provision of law, lordship. Section 50, my lord, of CRPC, lordship, clearly states that once a person is arrested, he has to be informed the grounds of his arrest. And that will be in compliance with the Article 22 of the Constitution of India, which is mandated by which is also reiterated by several judgments of the apex court, lords. So that is my main ground here in Malad. So for that, my lord, I think the record is also called for. So that will
The court has been
show
called
whether-
for.
my contention, my lord, is that he, at the time of arrest, was not informed, given, furnished a written copy, my lord, of the ground of his arrest. And that is in the case of Parquista and also Pancas, my lord. The apex court stated that that is
Where? Which judgment? Which citation?
Yes, your lordship. I think I'll go straight to the judgment, my
This is review petition. Put that. The previous review petition.
2024,
2024.
volume 8, lordship.
Volume 8.
254. That is in the case of Parvir Singh. Also. Parvir Purkist.
Para?
29, my lord. Parvir.
Wait, not ready yet. Yes,
If I may read, lordship.
20, yes, para 29.
This,
I think we should have
there are
another
also,
screen,
my lord,
yeah.
discussions here even in the whole of this judgment. But the relevant person will be, I think, this will suffice. And we can also go to some other paragraph, your lordship, if the need arises. And herein, your lordship, the apex court says that, hence, we have no hesitation in reiterating that the requirement to communicate the grounds of arrest or the grounds of detention in writing to a person arrested in connection with offense or a person placed under preventive detention as provided in the Article 22.1 and 22.5 of the Constitution of India is sacrosanct and cannot be breached under any situation. Non-compliance of this constitutional requirement and statutory mandate would lead to the custody or detention being rendered illegal, as the case may be. And coordinate bench of dishonorable court lordship has also passed order to on this ground also.
Where's that order? Where's the thing, copy of the arrest memo?
Arrest memo,
Yeah,
seizure memo is there, lordship. I think
it's
there
basically
is
the
already
arrest.
mark there in my lord, I think. Mark. But that, my lord, that formal seizure and arrest memo, my lord, doesn't amount to ground of arrest, lordship. That itself is distinguished herein also, my lord, in this same judgment, which I have referred to, lordship. I think it is marked as A in the flag.
In the
I think
TCR or in your?
in the TCR, lordship. Along with the learned
Wait, I'll just
PP,
have a look.
we have gone through that also, my lord. It is marked as A.
Seizure and arrest memo.
My lord. Herein, my lord, all the formal,
Everything is given here.
yes, your lordship. But, my lord, that itself is not the ground of arrest, which is required in terms of the judgment of
Copy
the
of
apex
this
court.
was given?
That, I don't know, my lord, because we have not received this also, my lord. And even if received, your lordship, that is not ground of arrest as required by the judgment, man, which I have referred to, lordship.
Report of seizure and arrest.
My lord.
Okay.
If I may take lordship to para
Of what? Para?
Kindly bear with me, Lordship.
Of the same judgment?
Same judgment,
2024.
Lordship. Same judgment, my Lord. 38, Lordship. 48. Sorry, my Lord. 48. Is your Lordship with me? It may be reiterated at the cost of repetition that there is a significant difference in the phrase reasons for arrest and grounds of arrest.
Yes.
It has differentiated between the reasons and the ground also.
Yes. Anything else? That's it?
Yes,
Okay. Then can we hear the additional PP if you have done with your...
yes, also.
Your Lordship, I believe the main ground that my learned friend have taken is that non-serving of the grounds of arrest. If I may take your Lordship kind attention to the TCR record that is,
Yeah, it's with me.
yes, I have marked it as A. And if your Lordship could kindly see that on the bottom of the page, on the bottom of the page, in the middle part, if your Lordship, Van Lelsundama accused, it's signed
Yes, yes.
and copied receipt. Now, in this seizure and arrest memo, it is mentioned that the SI have seized so and so amount of the seized articles from this and that person, and arrest is made in this regard. And intimation is also given to the relatives. So nothing, there is no specification in the apex court authority that my learned friend have relied upon as to how that grounds of arrest has to be written, or the standard format that has to be complied with. So, in my humble opinion, grounds of arrest is duly furnished in writing to the accused.
Yes. Okay.
And considering the nature of offense, it's 21C. The hurdles of
How much?
21C.
21C, and what is the amount of the seized article?
Amount,
Quantity?
the quantity is, it's 22 soap case.
Okay.
Okay,
Huge quantity.
yes.
Commercial.
Commercial, 21C.
Commercial, but even then, it could be just the borderline coming to commercial, or it's a huge quantity?
Your Lordship, it's 510 grams of heroin kept
Okay,
in
so
44
5
soap
kgs.
cases.
Okay, I'll reserve the matter for order.
Regarding the
order
matter,
accordingly.
if
Yes.
I may reply,
Yes,
give a short reply also.
in the memo of arrest.
In the, yes, memo of arrest and plus my lord, regarding that issue, how it has to be given is duly laid down by the apex court, my lord. Herein in the same paragraph which I referred to, lordship, paragraph 48, lordship. If I may read to, along with the lordship. It may be reiterated at the cost of repetition that there is a significant difference in the phrase reason for arrest and ground of arrest. The reason for arrest, as indicated in the arrest memo, are purely formal parameters, namely to prevent the accused from committing any further offense, for proper investigation of the offense, to prevent the accused from causing evidence of the offense to disappear or tampering with such evidence in any manner to prevent arrested person from making inducement, threat, promise, or to any a person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on charge of a crime, whereas so these are posed here for the moment, Lordship. All these which we have right now seen in the Caesar memo is common form, Lordship. This is common to all. And normally this is only the name are different, but the format is all common to all the arrests made in. But now, whereas it is stated here in that, my Lord, the ground of arrest would be required to contain all such details in hand of the investigating officer which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested, so as to provide him an opportunity of defending against custodial remand and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons of arrest which are general in nature. Which, now, we have found here in the arrest memo is general in nature, which is common to all the persons arrested in connection with any crime committed. But now, the grounds of arrest is different. So, differentiation has been made. Now, for that, my Lord, if I may take Lordship to another citation, please. For that, my Lord, there is one recent judgment in Lordship. 2025 SEC online, Lordship, SC 269. That is in the case of Vihan Kumar, Lordship, Para 21, Lordship. The Apex Court have laid down the manner in which the grounds of arrest has to be served to the accused person. Para 21, Lordship.
Para 20?
21.
21, okay. It is a question of repeated arrest. 21?
No, my Lord. Conclusion, Lordship. Conclusions. Therefore, is your Lordship with me?
In para 21? There's no therefore. Just scroll up, see para 23, 24. Just scroll up 23, 24, go up. Conclusion is para 25, 26.
Or 26, Lordship.
This para 26.
My Lord. The requirement of informing a person arrested on grounds of arrest is a mandatory requirement of Article 221. Information of grounds of grounds of arrest must be provided to the arrest party in such manner that sufficient knowledge of the basic facts constituting grounds is imparted and communicated to the arrested person effectively in the language which he understands. The mode and method of communication must be such that the object of constitutional safeguard is achieved. And number C, when arrested accused alleges non-compliance with the requirement of Article 22(1), burden will always be on the investigating officer, agency to prove compliance with the requirement. Non-compliance with Article 22(1) will be a violation of the fundamental rights of the constitution accused guaranteed by said article. Moreover, it will amount to violation of a right to personal liberty. So, Lordship, it has all laid down the manner in which it has to be in the language known to him. So it is different from arrest memo. That is my short grounds. Obliged.
I'll pass the order later.
Item 11.
1,062. 262 days. Yes, my lord, we have sent notice to the respondents and I believe that it's returned. The address which we have cited is the same address which was used by the by the petitioner and the respondents. Yes, Your Lordship. New Capital Complex. Yes, Your Lordship. We'll find out. Oblige.
Item 15.
Yes, may I please, Your Lordship. My Lord, these appeals arise out of injunction petition filed by the respondents, my Lord. So this case is, this appeal is connected to airship case, my Lord. My father had passed away.
Wait, what is this? What is it that you've given me?
This citation.
Hmm?
This citation.
Citations, but what is this? This is not a citation. Anyways, yes.
Yes, my Lord. I have obtained airship certificate number 167 of 2022 on 10 to 2020, my Lord. So my father had passed away on 30/5/2009, and my mother had passed away on 19/3/2015. So my father had left one property bearing LSC number AZL 17 of 1981, to which I have obtained airship certificate. And the respondent herein, being aggrieved, had filed one RFA 32 of 2022. So they have filed it on 24/8/2022. And the said RFA was disposed on 1/5/2023, my Lord. And in the said disposal order in the said RFA, my Lord, status quo was maintained as on 24/8/2022.
Where's that? Let's see.
Uh,
RFA,
yes, RFA.
page.
15, my Lord. 15 of my page. And at para 8, page 18, my lord, the status quo.
Status quo on the property in question. So when status quo is maintained,
Yes,
since
that's-
this is
that's-
an RFA, what would be the status quo? What would be the situation?
Status quo should be as on the date of filing, my lord.
So what is the position then?
That is, at the date of filing, my lord, I have been collecting rent
Okay, you were collecting rent. Huh?
from the property in issue, my lord. So,
Okay.
now, my lord, the honorable court had passed a status quo order.
So after this, you continue to collect rent?
Yes, yes, yes. And being aggrieved, the respondent herein had filed injunction petition
Okay.
before the learned trial court. So this, by filing CMA 163 of 2024, and wherein they have claimed that they have been collecting rent from the property, and I have forcibly disturbed their collection of rent, my lord. And to that effect, I filed my written objection. And if I take your lordship to page 28 of my,
Your brothers and sisters,
yes, no,
real brothers and sisters or step?
respondent number one is my sister, and 2 and 3 are my nephew and nieces.
Okay.
At page 29 of my petition, this is the affidavit submitted in connection with my written objection, my lord. So this affidavit states that I've been collecting rent from June 2022, my lord. This affidavit is made on 29/7/2022.
Who made this affidavit? You?
Me and my tenant.
Okay, your tenant is the one who is important anyways, huh?
So
Okay.
this proves that I have been collecting rent before the respondent hearing had filed their RFA. They filed on 24 August 2022 only. And I've been collecting rent from June 2022. At first, I have collected rupees 4,000, and by this affidavit,
Okay, now before June 2022, who was collecting the rent? The respondents?
no, my lord,
Then?
they were a separate tenant, my lord. This is a new tenant.
So the separate tenant, from the separate tenant, who was collecting the rent?
Me, myself only, my lord.
Okay.
And I've been the one residing at the property in issue itself, my lord. And the respondent number one was already having a husband and another house. And
So your nephew and niece the other respondents, they are the children of the
my sisters and brothers.
present respondent,
No, my lord,
someone else,
someone else.
some other brother and sister.
Yes. So, my lord, my main contention here is that since the honorable court has maintained a status quo order, passed a status quo order to maintain
This
a
is from
status
June 2022 and
Yes.
status quo order was passed on?
pass on 1/5/2023, but the RFA was filed on 24/8/2022. So,
22.
yes, my lord.
Okay.
So, the status quo is on 24/8/2022 falls in my favor. Now, secondly, the respondent had filed their injunction petition without praying for permanent and perpetual injunction, my lord. So, to that
Okay,
effect,
we'll have a look at the impugned order.
Impugn order is at Roman number 3, my lord. Just after the index. At para 6, my lord, is the operating part.
Para?
Para 6, my lord. If I may. Considering the facts and circumstances of the case, it appears that the applicants have prima facie case. It's, my lord, let me read it from para 5, my lord. So it will be much more clear. From perusal of the application and objections submitted by the parties and after hearing the learned counsel for the parties, the main contention is who had collected the rents from the property in question before filing RFA 32 of 2022, as the Honorable High Court had directed to maintain status quo on the property in question, and both the parties had claimed that they had indeed collected the house rent before filing the said RFA. Peruse the copy of RFA number 32 of 2022. On perusal of applicants, on perusal, the applicant number 1 and 2, who were the appellants in the said RFA, had specifically stated in para number 4 of the petition that they are still collecting rents from their respective shares of the property till date. As for impleading the applicants as they are parties to the heirship certificate, case number 167 of 2020, a separate impleadment application or order is not required, as the Honorable Guwahati High Court has already said in its order dated 1/5/2023, given opportunity to all parties interested in the property concerned to contest the case. Considering the facts and circumstances of the case, it appears that the applicants have prima facie case and the balance of convenience is in their favor, and if the OP is not restrained from collecting house rents from the property in question, the applicants may suffer irreparable loss. Therefore, application is allowed and the OP is directed not to interfere with collection of rents by the applicants from their respective shares of the building situated within LSC number so and so till final disposal of heirship certificate case number 167 of 2020 or until further orders. My lord, my humble submission here is that we are now under trial, my lord. Both parties have yet to prove who will inherit my father's property. So, forcibly allowing them to collect rents, specifically the respondent number 1, from 1 and 2, from property in issue, while I have been collecting rent prior to the filing of RFA 32 of 2022 will not be proper. My lord, with regard to respondent number 3, respondent number 3 is still collecting his portion of rent till date.
No, so it is respondent number 3 who's collecting the rent.
Respondent number 3 is collecting his portion, and I'm still collecting my portion.
So what's your problem then? If you're still collecting your portion, he's collecting her portion.
Yes, my lord. So the question is that I was no longer allowed to collect rent from the property in issue, my lord.
Okay, where's the property? There's one property, huh?
Yes.
What is the property, LSC?
LSC number AZL 17 of 1981.
1981.
And I'm
Which
residing.
is, you're residing in that property?
Yes, my lord.
Then where's the question of tenant?
Residing at the top floor, my lord. There are
Top
several floors, my lord.
How many floors?
Around four floors.
4 floors. So 4 different tenants?
Yes.
4 tenants. So all the tenants were giving you the rent, is it?
Yes. No, my lord.
No?
From one One
be clear.
person, the respondent number 3 is collecting rent from
Okay,
one.
so now there are 4 tenants. From one of the tenants, respondent number 3 is collecting the rent.
His
from
portion
one,
of rent, yes.
one tenant. The other 3 tenants,
There is only 3 tenants.
Fourth floor is mine.
okay,
my
so
lord.
there are 3 tenants. So from one tenant, respondent number 3 is collecting that. There's no dispute over that.
Yes, my lord.
No dispute. It belongs to him,
Yes.
that floor.
Yes.
So there's a dispute regarding the other 2 floors,
Yes,
remaining 2 floors.
But that is also not correct. The respondent number 3 is collecting rent from the share of the respondent number 1 as allowed by her. In fact, there is 4-story building. It has been distributed by way of a will, and it has been accepted by the parties concerned herein. The
So let's get the facts straight, then we'll understand your submission.
No, my lord. The alleged will, what he has stated, the
Will
alleged
is
will,
challenge, under challenge now.
no, is not under challenge.
Not challenge.
Not
Then-
probated. I obtained heirship certificate directly, wherein the respondent number 3 and his mother were signing no objection. And therefore, the learned trial court had issued me the heirship certificate. There is no probate
So
of will.
before the issuance of the heirship certificate, who was collecting the rent?
Me, my lord.
Okay.
Because I'm the
from,
one
From one of the tenants or 2 tenants?
from 2 tenants, my lord.
From 2 tenants.
Yes.
Then
And I have allowed respondent number 3 to collect from 1.
from one of the tenants. So now you have come into this court regarding collection of rent from one tenant only,
No, my lord. From 2 tenants.
2 tenants.
Yes. One is still collected by, I have allowed respondent number 3 to collect rent from,
You allowed.
yes.
But the 2 remaining, you want both of them to
Yes, my lord.
be collected by you, while from the 2, one is collected by respondent number 3 till date.
Yes, ma'am.
And the other remaining one, number 1, is also now collected by respondent number.
No, my lord, I
3.
am still collecting rent till day.
You're
But-
collecting?
Yes,
Okay.
but there is an order stopping me, to stop me from collecting the said rent.
But you have not obeyed the order. But you have not obeyed.
But
You're
that
still
is why
collecting.
I've filed this instant appeal. So my next point is that they filed their written objection to the said heirship certificate, wherein they have not prayed for any perpetual or permanent injunction against me, my lord. So without praying for perpetual and permanent injunction, simply claiming for interim injunction is not permitted, as decided by the Honorable Guwahati High Court in review petition 187 of 2017 and IA civil number 4221 of 2017.
So here, wait, look at the order. Let's look at the impugned order.
Yes, ma'am.
Para 2 of the impugned order.
Yes.
So the applicant is the respondent number. In the present appeal, applicant is
Applicants are respondent number 1, 2, and 3.
1, 2, and 3. They are prayed for ad interim order to direct opposite view not to collect rent from the ground floor,
Yes.
first floor and third floor of the building.
Yes.
So when you say not to collect rent from the ground floor, first floor and third and second floor, 3 floors.
Yes, my lord. 3 floors, as we have said earlier.
Okay, now 3 floors. Now you had allowed the respondent number 3 to collect from which floor?
I'm not exactly sure which floor, my lord.
That's what you said. See, now you are collecting the rent from ground floor, first floor and second floor right now. Is it from all the floors?
From all the floors, I
You
used
are
to collect. I used to collect, but now I have allowed the respondent number 3 to collect from 1 floor.
Which floor?
That I have to inquire from my client, my lord, because I have just received this information last night, and I've
Okay.
allowed, saying that I've allowed respondent number 3 to collect the rent.
from one of the floors?
Yes, madam.
Okay. So now you have come to this court saying that you want to collect from the other 2 floors?
Yes, my lord. With no disturbance, madam.
Anyways, so now an ad interim order was passed against you not to
Yes.
collect rent from the this thing, okay? Till from the month of March till the final disposal of the instant application. So you were stopped from collecting. Who's collecting then? In between, an ad interim order was passed that you should not
Yes.
collect the rent, isn't it?
Yes.
After
No
that,
one has collected at that relevant point of time, madam.
so who's collecting right now? No one.
Right now, I have collected the rent because I filed there in my instant appeal, madam.
You are their brother,
I'm
Or
the
sister.
sister, madam.
sister. So, supposing your brothers and sisters, okay? Supposing we give an order that the rent should be deposited in the court before the disposal of the the airship
That
certificate.
would also be fair, my lord.
Can we do that?
Yes. From all the 3 floors, let it be collected, deposited to the court, my lord.
We need to submit to the court the rent that she collected.
Pardon?
If she's willing to submit to the court the rents that she collect as on date, so then I will.
Then I think we can let that be deposited into the court by this thing, and once the matter is disposed of,
The rightful owner will collect the rent.
collect release.
Yes.
That will be a very simple way of
Yes,
solving
yes.
this problem.
Since they are all family, my lord.
No, you all are brothers and sisters.
Yes, my lord.
In fact, if you, in the meantime, if you can settle your matter, you share the rent. What? Because the building must have been built by your parents.
Yes, my lord. But my learned friend, what my learned submission regarding the facts is not correct. It's a 4-story building. The top floor
Built by your parents.
built by our parents.
Ah,
The
they
top floor
passed away?
The top floor
Ah.
is occupied by her, and the third floor is occupied by the respondent number 3 along with the deceased. And it is the ancestral home. And the respondent number 3 supported the deceased till her death. And
Those are facts we have to
and
see
yes,
how.
and there are 2 compartments in the second floor. One compartment she's forcefully collecting the rent, and another compartment, the respondent number 2 is collecting the rent through the respondent number 3. Respondent number 1 is collecting the rent through the respondent number 3. And the ground floor is supposed to be the property of the respondent number 2. However, she has disputed that and she has been forcefully collecting the rent. In fact, my lord, this
I think you were supposed to come to some settlement, isn't it? How much is the rent from the
rent
ground
she
floor?
collected is 14,000 from one compartment of the second floor and the ground floor. So if that be deposited to the trial court, then we have no objection, my lord.
Let it be deposited, my lord.
In fact, my lord,
Let all of us deposit.
in fact, my lord,
That would be fair.
She already admitted that they were all the respective owners of the property in question as distributed by her father in the writ petition filed by her before this court, which was eventually dismissed after the demise of her mother. She tried
See,
to
you're
grab
wasting
everything. That is the problem.
Why do you this thing over a few thousands brothers and sisters fighting? I don't understand. You should try to settle these
It's
matters.
not so greedy then.
No, both of you are finding each other.
Everything can be.
I think one of the parties should be more generous, not
fact,
greedy.
my lord,
Someone be generous, say, okay, take, and then you can settle. Because ultimately, a few thousands will not make so much of a difference. What
fact,
is
my
more important is your relationship.
Yes, my lord.
Blood, you have the same blood, will you?
Yes, my
See,
lord.
if the parents were alive and they get to know that you are fighting over all their hard work, they would have never built such a building.
My lord,
At
Just
the end of the
causing
day,
trouble
we
in
are
the
all
family.
family members. My lord.
if you lordship allow me to submit just a few points. If I may take your lordship to page 11 of my affidavit. Page 11 of the affidavit filed by the respondent number 1 to 3.
You see who is right, who is wrong
Yes.
over a few, this thing, thousands is not worth it.
Just so your lordship
Huh.
might have a better understanding of the case.
Hmm.
Page 11 is the writ petition filed by the present appellant against her mother and the state government. If you turn to page 13,
1-3.
1-3, paragraph number 5, the deceased CBF Lena during his lifetime executed the will dated 13/12/2008, distributing the concrete building located in the land settlement certificate number 17 of 1981, floor by floor. This is at annexure 1. Annexure 1 will be at page 19.
Anyways, that's
So,
a different matter. You
no,
are
my lord,
fighting
what
her.
I'm trying to say is
Huh.
that even she admitted that it was already distributed between them. And the will also clearly states that the other respondents will have a share to the property. But once the mother died, she tried to grab everything. In fact, in our prayer, in our counterclaim before the trial court, we just want our respective share. We don't want to disturb her share. But now she's intending to disturb everything. That is the problem we're facing.
No, now you're saying that from one of the floors you have allowed your sister to collect the rent, isn't it?
No, respondent number 3 is my nephew, my lord.
Nephew.
Yes.
You have allowed your nephew to collect the rent.
Yes. And
Then,
It's not so much as allowed.
so now if we deposit all the rent in the trial court, all
Yes.
three of you will be suffering.
yeah. Let us all suffer and it will be fair. So,
Okay, my lord.
because
Because then it's the easy way
if,
of disposing of
if
this
one is
FAO.
allowed and another will be jealous, my lord.
Ultimately, I feel you should just distribute the money properly between yourselves.
In fact, my lord, she has already established a separate home with her husband in the top floor. And the respondent number 3, who is her nephew, has supported the deceased till her death. So, in terms of the provisions of the...
Supposing all the rent is deposited in the court.
Okay.
Ultimately, if one of you succeed,
Yes.
I think it will be fair if you still give some of the rent to them. This give some amount at least, because a lot of money would have collected. They are not different people. See, when you are family members, only one family member becoming too rich and the others very poor still reflects badly on the rich family member, because he's not looking after his other members. So Sheikh, and these
Okay,
little
ma'am.
things don't, this thing is, so as counsels also you should advise them like that.
Pardon, madam?
As
Yes,
counsels for the parties
definitely.
also, you should advise
They are
them so
ultimately
that
they are family
try and
members,
have a
madam.
good relationship.
Yes.
One family member becoming too rich and the others being poor reflects badly on the rich family member also. It
Yes,
doesn't
madam,
look nice.
We are all on the same boat. The respondent number 1, 2, and 3, as per the will. But the present appellant, she wants to take everything. That is the problem. In fact, our prayer before the trial court.
So if you allow her to take everything, she'll give something back.
Yes, as our prayer is also that the property distributed. As
Have
per-
you tried to settle the matter before Lok Adalat?
My lord, they are not in a position to talk with us. That is the problem. We tried everything.
So,
In fact, even after the passing of this impugned order, she has been forcefully collecting the rent, and she has been scolding her nephew quite some.
In fact, my lord, I'm not the
no. So refer the matter to Lok Adalat first, because Lok Adalat you have experienced conciliators instead of trying between yourselves. Because the matter I don't think is such a big this thing.
in fact, my lord, I'm not the
And
counsel in the
no way, your
trial
parents
court.
they have executed, they have left a will, is it? So
Yes, ma'am.
is the will being challenged? Are you agreeable to the will?
We are agreeable to the will. But
So
she's
if
not.
if you admit that your mother or your father has made a will, Then in the Lok Adalat, everything is possible. You all look at the will and try and settle the matter. I don't think it's a matter which is very difficult to settle. Because if you continue a civil suit, then your relationship, brothers and sisters, nephew, will start deteriorating and get worse. You
Yes,
see,
madam.
because then
That is correct.
ultimately both of you will say, we have waited, we have spent so much money on our councils, we don't want to settle. So that the family then just try and settle. So we'll refer the matter to Lok Adalat.
Yes, yes, ma'am.
Experienced consolators are there. However, the consent of the parties is required. Before you take the consent, we cannot simply refer.
Yes, madam.
So when can we list the matter again?
You can set it directly also, madam. My time will be agreeable if this we need to.
Do you need to take the consent of your client?
Yes, my lord. I'll.
Okay, yes.
We can-
We'll make an attempt, then the whole thing, the civil suit will also be settled if you can settle this.
Yes, madam.
The FAO.
Madam, and since we're both agreeable to the deposition of Saran before the High Court, the person may be kind enough to pass in order that in the interim the
No need. Try and settle first. Whatever status quo, if she's still collecting, let her collect because you're not different people anyways. But Mr. Lalbiak Nunganamte, Learned Counsel for the appellant, along with Mr. Zoram Chana, Learned Counsel for the respondents. Having heard the submissions made by the learned counsels and considering the nature of the dispute, which is between the siblings and the nephew and niece, is it?
Yes, madam.
Nephew and niece. Of the appellant. This court find that this matter appears to be appropriate for settlement through Lok Adalat. In view of the above, the learned counsels for the parties will inquire from their clients whether the parties are willing to have their matter referred to Lok Adalat. List on, when you want it,
tomorrow Friday, Monday.
okay, list on 21st, okay, 21/7/2025. Okay, find out where they're residing in Aizawl. Both of them are from Aizawl, is it?
All from my.
Then you can contact them.
Obliged, ma'am.
Unlisted item.
Yes.
First of all, my lord, I beg your pardon as I have to cut the line since my colleagues are waiting for their cases, which is in the board. Now, my lord, this is a case of part-time assistant professor who have been engaged as professors in various colleges under the government of Mizoram. Now, their terms of engagement recently is from 1/3/2025 to 28/2/2026. Now, while our terms of engagement is still valid, the government respondent number 4 has issued a so-called notice, which will expire today. Now, we are challenging the so-called notice because it is illegal, first of all, and despite the fact that our terms of engagement ends only on 28/2/2026, we have been issued a so-called notice. And that so-called notice is only a veil that the government has complied natural justice principle. In fact, there is an impending decision of the government to terminate our service and shorten our duration of this engagement. If I may take a lordship to the approval of government for our engagement, it's at page 29, Madam.
Page
29.
29.
My prayers here are very limited, my lord. Here, if I may read, my lord, In inviting a reference to a letter so and so, I am directed to convey herewith government approval for extension of engagement period of 29 numbers of unqualified part-time assistant professors of various government colleges for a period of 1 year, that is 1/3/2025 to 28/2/2026 on humanitarian ground, to enable them to obtain the required qualification as below. Now, my lord, the required qualification as per UGC regulation 2010 for a regular employee is net or PhD. Now,
Okay, so they all are non-net.
yes, we are not having this qualification as of now, but we have been given the time to have this qualification till 28/2/2026. Now there are 29 persons in this letter, my lord. The
Okay,
petitioner
how often can you give your net exam? Isn't
net exam is normally it is 2 times in a year, but it is difficult to pass PhD within a year. So we cannot take any leave, casual leave for doing that research work if we are to do PhD within a year. So here there are 10 petitioners, 19 did not come before this court. They have chosen to file a reply to the so-called notice, waiting for the mercy of the government. Now we have come before this honorable court because we feel and we are the under impression that that so-called notice is only a precursor for our termination, which this has not been taken into account. This letter has not been taken into account by the government. Now there is a recent interview by the Honorable Minister of Education and Human Resources Development, wherein the Honorable Minister has expressly stated that we are going to be terminated. Now there is a clip which I have produced here in my
anyways,
petition.
so this is you were given chance till 28/02/2026. So after 28/02/2026, if you don't attain this, then
I
you
am not
can.
claiming any right. I am not claiming any right for regularization.
So where's the show cause notice copy? Page?
I'll come to that, my lord. Page 42. Now this is in respect of respondent number 5, and all the so-called notices are the same in respect of all the other persons.
So this, the second last para.
Yes, my lord.
Now therefore to explain it as to why your engagement shall not be terminated. Maybe it will be after this thing, 28/02/2026.
No, no.
Not immediate termination.
They are intending,
Because
my lord.
no, nothing immediately nothing is given.
No, I am producing the clip of the press conference of the Honorable Minister, wherein he has expressly stated that our duration will be shortened, and we are under the impression that we are going to be terminated.
To has not and is to reconsider the engagement currently approved till they have to reconsider.
If it please your lordship, I have annexed that video clip in Annex 9.
Anyways, we'll issue notice first. Let's see what they have
In
to
the
say.
interim, your lordship may kindly stay the impugned stay so-called notice.
Yes, okay. But Mr. C. Lal Fagzwala, Learned Counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India, challenging the impugned order dated 03/07/2025, challenging the show cause notice, okay, not impugned order. Served to the petitioners as to why their engagement as part-time assistant professor shall not be terminated. Full stop. The Learned Counsel for the petitioner submits that for the petitioners, okay, that the petitioners were engaged as part-time assistant professors under the government colleges for a period of 1 year with effect from 01/03/2025 to 28/02/2026 on humanitarian grounds to enable them to obtain the required qualification, provide an order dated 21/02/2025. Full stop. However, before the period of the engagement till 28/02/2026 expired, they were given this impugned show cause notice. Full stop. The Learned Counsel further submits that he has evidence which indicate that the petitioners were likely to be terminated before the period of the engagement till 28/02/2026 is over. Which would be a violation of their fundamental rights under the Constitution of India. Notice be issued. A notice of motion be issued to the respondents. Full stop. Then Mrs. Mary L. Kiante, Learned Government Advocate, accepts notice on behalf of the state respondents. Requisite copy of the writ petition to be duly furnished to the Learned Government Advocate. Full stop. The Learned Counsel for the petitioner further submits that unless the impugned show cause notice dated so and so, is stayed, there is a possibility that the petitioners would be terminated before the period of engagement is over, and therefore prayed for stay of the impugned show cause notice. Considering the nature of the submission made by the Learned Counsel for the petitioners, this court find it appropriate that the operation of the impugned show cause notice dated
Worship,
3/7/2025.
status quo may be maintained and the matter be listed next week, because considering the nature of the general public interest that is involved here, I think that status quo would be enough. Till next returnable date.
We'll stay.
We'll
this-
stay,
this thing till
and
the
no
next
detrimental
date,
action may
so
be
that
taken
they're
till-
not this thing.
Your
Till the
Worship,
next
with due
date of
respect,
the.
Your Worship, they were engaged in the year 2012. Now, after more than a decade, after 13 years from the date of their initial engagement, they failed to acquire the minimum requirements till date. And considering the general public interest, that is the student of all the universities, the colleges here in Mizoram. So only this 10 numbers of petitioners would, I think there should be some balance, Your Worship, considering the nature.
Okay,
the
same
general
thing.
interest.
Status stay and status quo is the same thing.
There are
Okay.
90 persons who
Wait. Considering the nature of the submission made, well, this court finds fit that status quo should be maintained
So
Till next
regarding
returnable date,
the till the next date of listing.
and next week.
if you're
is
not
next.
kindly please mention that so post office, because it is my specific prayer, because they will interpret in their favor if they say the status quo.
No,
I-
we'll see. We have seen your distinct nature of your
It is not my prayer
submission.
to maintain the status quo. Because it is my prayer that this so post office may be safe and no detrimental.
Okay, anyway, Learned Counsel for the, which is objected by the Learned Counsel for the Learned Government Advocate, who submits that the petitioners were engaged as far back as on
2012.
2012 and have not attained the required qualification till date. and therefore it is in the interest of justice and for the it is in the interest of the general public and the students that such a show cause notice has been issued. Full stop. Considering the natures of the submissions made by the learned counsels for both the parties, this court find it appropriate that status quo be maintained till the next date of listing. Yes, list after 3 weeks. Or list after 2 weeks, because
Action may be taken against.
no, the status quo maintained means they will not be terminated. You can relax.
Just before I go out of the door, I may be terminated. I think.
So that's why status quo be maintained, isn't it?
Apply.
List after 2 weeks. Okay.
Up to item 2.
Now it's going to be time for lunch break. 2-3 minutes left.
Yeah.
Yeah.
Your
3
Lordship,
minutes. So we'll continue. This is
Item
hearing
two.
list number 2.
Your Lordship, in this matter, the state is the issuing authority of the LSCs. So may I take your Lordship leave to?
Okay, you
Yes.
will adopt whatever submissions are made by
Yes,
the
because it's found the dispute in personal.
between two private parties. States have nothing to say. Huh? Will this thing start at 2? But before that, I think today is a reference for the some of our judges, senior judges. So I don't know if we'll be able to have this matter today. Okay, the reference matter is there today.
If it's going to take long, Lordship, this matter may be taken up next Monday. Then.
On Monday.
Monday.
Okay, because I think all the courts have to rise by 1, and whether how long it's going to continue, I don't know the reference. So,
My lord, Monday as a fixed matter, if we can have it.
on the submissions made by the learned counsels for both the parties, list on, what is Monday's date?
21st.
21st, 7, 2020. 5, yes. There's also one more matter.
Yes, my lord. Item number 9, 10, and 11
Ah.
is fixed for today.
So when can we do it?
Maybe taken up next week.
Okay, this is
On
matter
which date, my lord? If
on when?
Thursday
Thursday.
or
24th, lots of matters have been listed. We'll make it on 25th. Next week, 25th? Friday.
my lord.
Okay, we'll, as a fixed matter, okay, 25th, yes.